accompany Honorable Justice A.P. Shah, former Chief Justice of this High Court, onto the stage. I request Ms. Neelavati, Advocate, to come and render Tamil Thai Vaalthu. Can we all raise, please, for the song?
நீராறும் கடலொடுத்த நிலமடந்தை கிளிலொழுகும் சீராறும் வதனமென திகழ் பரந்த கண்டமெதில் திக்கணமும் அதிச்சிறந்த திராவிடனல் திருநாடும் அத்திலக வாசனை தக்க சிறு பிறைநுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
Thank you, Neelavati. As one of the initiatives of the Tamilnadu Senior Council's Forum, a decision was taken to celebrate and commemorate the 75th year of our Constitution. As a step towards it, a series of lectures are being organized. First of those which was rendered by the Honorable Justice U.U. Lalit, for the former Chief Justice of India. Today we have amongst us Honorable Justice A.P. Shah, former Chief Justice of this Chartered High Court, as also former Chief Justice of the Delhi High Court, and the Chairman of the 20th Law Commission, to deliver the second series of lectures. A warm welcome to you, sir. To elaborate further on the subject, I request Thiru A.L. Somayaji to come forward and deliver the welcome address.
Respected and Honorable Justice A.P. Shah, Justice M. Ravindran, retired Judge of this Court, Justice M.S. Ramesh, Justice S.S. Sundar, Justice Satish Kumar, Honorable Mr. Sharma, Justice Sharma, Anand Venkatesh, and my dear friends. It is indeed my pleasure to welcome all of you in this evening. I know that after a tiresome day, you have chosen to come here and take part. I am really grateful to all of you, including the judges. Their job is more tiresome than a lawyer. So I want to say a few words about this forum. This forum was started a few years back, and it consists of mainly senior advocates of the state. And we have taken up recently, sir, we have decided to organize a lecture for young lawyers, that is a training program in collaboration with the Bombay Bar Association. It appears that they have got some tie-up with a Malaysian training program, and in fact that program is to be done on this Saturday, Friday evening, Saturday, Sunday. And it is, the trainers are from Bombay, 18 of them, and 4 of them are friends are also there. So this program is mainly meant for advocates having a standing of 1 to 5 years. I don't know, sir, excepting a few, many of those present here would not have had apprentice even. In fact, my batch was the last batch to have apprenticeship as a compulsory program. You have to undergo for 6 months. Thereafter, you have to write the exam and pass the exam, then only you are entitled to be enrolled as an advocate. Sir, in this program, they are given a case and they are asked to study, and they are asked to prepare a plaint, written statement, how to prepare the evidence, and how to chief examine them, how to cross-examine them, how to advance arguments. One more factor is that all these things are conducted in a court hall, and this honorable court was kind enough to allot 5 court halls for this purpose, and we are getting it done. So it's really, sir, very, very good program which has been initiated by this forum. Apart from this, we are doing various charitable activities. We contributed about 1.85 crores to the Cancer Institute. And we have started this 75th year of Constitution Day, and the first lecture was given by Justice Lalit. And we have been fortunate to have you amongst us. And we are really grateful to Justice Shah, who readily accepted our invitation and be present here and agree to deliver the lecture. I need not say anything about Justice Shah. All of you know him better. He is very candid, outright, outspoken, and at times brutally frank in expressing his views. And results are known. It is really fortunate that he has agreed to deliver a lecture on this subject, and I don't want to stand between you and Justice Shah, and I welcome each and every one of you, and I am grateful to you for being present. Thank you.
I request Mr. Om Prakash, a co-convener of the forum, to felicitate Honorable Justice A.P. Shah. On popular demand, Mr. Somyaji sir will also join Mr. Om Prakash sir in felicitating the Honorable Justice A.P. Shah. Now may I request Mr. Ravindran, former Additional Solicitor General of India, to kindly render his address.
Honorable Mr. Justice Ajit Prakash Shah, my good and noble friend A.L. Somyaji, convener of the Tamilnadu Senior Advocates Forum, Mr. Parthasarathi, co-convener, Mr. Om Prakash, secretary, honorable judges past and present, and friends. Mr. Somyaji, his co-conveners, and our dynamic secretary Om Prakash have selected an apt, proper, and right person to deliver the special address today. It is apt because Justice Shah, when he was the Chief Justice of our High Court, decided to celebrate the 60th year of our independence in 2007. He wanted to celebrate it in a unique way by arranging lectures to be delivered by eminent persons from various fields of activity. He was kind enough to nominate me as convener for this lecture series. Mr. P. Chidambaram, then Union Finance Minister, Mr. Venkatapati, then Union Minister of State for Law, Mr. Raghavan, IPS, former Director of CBI, Mr. Lakshmi Narayanan, IPS, former Additional Director of CBI, delivered lectures. Before we could arrange further lectures, I was appointed as Additional Solicitor General of India in April 2008, and Justice Shah was transferred to Delhi as Chief Justice of Delhi High Court in May 2008. Therefore, the gentleman who envisaged a majestic celebration of the 60th year of independence, is the right choice to deliver the special address today to commemorate the 75th year of our Constitution. The judgments of Justice Shah were far ahead of the time, be that on application of RT Act to the office of the Chief Justice of India, or the decriminalization of homosexuality, or his views on collegium system, or criminal justice and prison reforms. He cares deeply about this last topic, namely criminal justice and prison reforms, and about the sad situation of our prisons being flooded with under-trials. As I see it, the common theme in these judgments is the belief that the Constitution should work for all Indians, whatever be their religion, caste, gender, ideology, or financial status. After retirement, the learned judge continued with this approach in his role with the Law Commission as chairman. He has been outspoken in public forums and has addressed the media on pressing issues of contemporary law and society. It was a privilege to interact with him when he served as Chief Justice of this esteemed court, and it is truly a pleasure to welcome him back today. As appropriate as the keynote speaker is the topic selected, Constitution, Secularism, and the Supreme Court. I understand this topic was selected by the guest speaker himself. All Indians like to discuss this topic in public and in private. Discussion and debate are good, but quite often we see legal misinformation and creative license in these discussions. Today's forum is different because we have invited an expert to address this topic and to enrich our understanding. Be it Article 25 or any other provision in the Constitution, we know that secularism is the core aspect of our identity. The Constitution touches upon matters that go beyond freedom of worship, namely the management of religious property and the state's role in linguistic education. These are matters of national importance. Just a few months ago, the Supreme Court reaffirmed that secularism was in the basic structure of the Indian Constitution. I have always been astounded by how our founding fathers and mothers had the confidence to leave us with such a sophisticated constitutional system. India's literacy level in 1951 was below 20%. Poverty level in 1951 was about 55 to 60%. We had the ongoing trauma of partition. The country was preoccupied with linguistic and caste debates. Yet the architects of the Constitution were confident in the capability of the Supreme Court. They trusted the ability of Indian citizens to know their rights and responsibilities. Do we truly know the intent of the members of the Constituent Assembly? How did Baba Sahib Ambedkar and his colleagues want the Supreme Court to address basic structures issue? The notes from the constitutional debates give us a good understanding, but we do not know many of the background stories. A few years ago, some of my younger family members made me to watch this wonderful musical production known as Hamilton. The creators of the show made every American pay attention to their country's constitutional history. They set the life story of Alexander Hamilton to mesmerizing rap music. Hamilton was one of the founding fathers. He arrived in colonial America in 1772 as a destitute teenager. He worked hard and studied to be a lawyer. He fought alongside General Washington in the War of Independence. He became the first Treasury Secretary of the USA and worked with Thomas Jefferson and others. This dance drama brought to life the great American constitutional debates and the conversations held by these historical figures. Someday we might have a film or drama that captures the conversations of our founding fathers and founding mothers. For the present moment, however, we are blessed with some great legal and judicial minds who can interpret the Constitution for our times. Justice A.P. Shah is eminently qualified to do this task. I look forward to hearing his thoughts on the Constitution, secularism, and the Supreme Court. Today, generations of senior advocates are present in this hall. All of us stand to gain from engaging this topic. Thank you.
Speech. Now the moment which we have all been waiting for, I invite Honorable Justice A.P. Shah to render the second of the series of the lectures on the 75th year of the Constitution.
Judges, members of the bar, students, ladies and gentlemen, a very good evening to all of you. Returning to the Madras High Court after a decade and a half, having once served as its Chief Justice, is a deeply emotional experience. The grand colonial architecture, the familiar echo of legal arguments in its corridors, and the very air imbued with history all evoke a flood of cherished memories. Returning here feels like returning to a second home, where I recall the camaraderie with fellow judges, the passionate advocacy of the bar, and the collective pursuit of justice. The Madras High Court boasts a rich and illustrious tradition, having nurtured some of the finest legal minds in the country from the colonial era to the present day. It is impossible to speak of this tradition without acknowledging towering figures such as the legendary senior advocate Keshava Iyengar, the father of Sri Parasharan, whose legal acumen and ethical standards set a benchmark for generations, and Govind Swaminathan, who was known for his commitment to the finest judicial values and for upholding the Constitution and the laws without compromise. These stalwarts, along with countless others, have shaped the legacy of this court and continue to inspire us all even today. This return is particularly special as it is for this lecture series commemorating the 75th year of the Indian Constitution, which gives us occasion to reflect on the foundational principles underpinning our democracy. Today my talk will focus on Constitution, secularism, and the Supreme Court, a topic of paramount importance in our diverse and pluralistic society. Secularism in India is very different from its Western counterpart. Indian secularism is complex and multidimensional, much more than tolerance, and certainly not merely Hindu tolerance. It represents equal respect and treatment for all, regardless of religious beliefs, actively promoting social justice. This is also the idea enshrined in the Indian Constitution, which seeks to build a modern, inclusive nation where citizens feel they belong and can participate equally. My visit here made me revisit the views of E.V. Ramaswamy Periyar on the subject. He approached secularism less as a political ideal and more as a prerequisite for social justice and equality. Periyar's rationalism, rooted in his critique of Brahminical dominance and religious superstition, emphasized Pakkathariva, Tamil term for reason or intelligence born out of discernment. For him, secularism was linked to this rational faculty which made people question oppressive social norms and religious dogmas that perpetuated inequality. For him, true social reform entailed a secular rationalist approach that challenged traditional power structure. Periyar's secularism differed greatly from that of the Constituent Assembly, which focused on the state's neutrality towards religion and protection of religious freedoms. Periyar spoke of individuals' right to be free from constraints by religion. Periyar's secularism, while perhaps less concerned with the Constituent Assembly, reminds us that the true purpose of secularism is to create a society where everyone is treated with dignity and respect regardless of religious beliefs. Today, with increasing religious extremism, communal tensions, and the politicization of faith, a renewed focus on secularism's core value and the constitutional framework becomes imperative. The Constitution was designed to navigate the complexities of state partiality, impartiality, protection of religious freedoms, and equality regardless of faith. How we must uphold the spirit of the Constitution today to ensure that secularism remains a bedrock of our democracy. These are some thoughts I hope you will leave with after my lecture today. I will briefly outline my thoughts on secularism and the idea of India and consider the constitutional scheme for secularism contained in the fundamental rights. I will then examine the nuances of Bommai decision and the essential religious practices test, how it has been developed by the court, and tackle a few important judgments. Finally, I will consider the relevance of all this in the light of the Hindutva cases and more recent developments in Ayodhya and Gyanavapi. Secularism was foundational to the idea of India as the only way to forge a united nation from a diverse populace. Political leaders, particularly with partition, recognized the need to transcend religious and communal divisions. Secularism was thus not just a political expediency, but a moral imperative. The Constituent Assembly's debates also reflect differing views around how to handle religion. Ambedkar wanted to stay out of religious matters. Others like K.M. Munshi felt India's religious traditions needed to be respected. H.V. Kamath even proposed including the words "in the name of God" in the preamble, but this was rejected. And it was decided all religions should be equally respected, resulting in what some call an agnostic constitution. In this manner, Indian secularism did not merely imitate Western models, but responded to its unique historical and social realities, recognizing that a state favoring one religion would lead to the alienation and marginalization of others. Secularism was essential for social harmony and political stability. India's model of secularism has been described as a principled distance between religion and state, which is different from the Western wall of separation between church and the state, with its more strict and rigid division. With principled distance, the state engages with religion when needed to uphold constitutional values. But this is also complicated. What does principled mean? Who does what distance should be maintained and when? If you say that the Constitution allows religious practices to be reformed, the distance is less clear. Constitution secularism is better understood, I feel, using Rajiv Dhawan's explanation. which breaks down the concept into three parts. Firstly, religious freedom, which covers religious beliefs, rituals, and practices. Secondly, celebratory neutrality, which refers to a state that assists in the celebration of all faiths. And thirdly, reformatory justice, which involves regulating and reforming religious institutions and practices while setting aside core element beyond regulation. The Constitution constructs a secular state through a network of fundamental rights, ensuring both religious freedom and equality. State neutrality is established in Article 27, barring public funding of specific religions, and Article 28(1) prohibiting religious instruction in state-funded institutions. Guarantee of religious liberty are in Articles 25, 27, and 28. Article 25(1) enshrine freedom of conscience and the right to profess, practice, and propagate religion. Article 27 protects individuals from taxes earmarked for religious promotion. Article 28(3) safeguards students from compulsory religious participation in schools. Article 14 and 15 enforce equality and prohibit state discrimination based on religion, race, caste, state, sex, and place of birth. Article 29(2) ensures equal access to state education. Article 325, with universal franchise, ensure equal electoral participation. But Indian constitutional secularism also has unique aspects. Article 31 recognizes religious minorities' rights to establish and administer educational institutions. Article 32 mandates state aid to these institutions, even permitting religious instruction in partially state-aided schools, thus recognizing the need of supporting the minorities. Article 25(2)(b) also permits state intervention in religious affairs for social reform, allowing laws that open Hindu temples, religious institutions to all, and address discriminatory practices. Article 17, abolishing untouchability, reinforces the idea that Indian secularism is an active force for social transformation. However, this constitutional secularism has also exhibited polarization. A framework for religious harmony has perversely fueled endless conflict. Differing interpretations have devolved into bitter disputes, particularly around religious convergence, the Uniform Civil Code, and the management of religious institutions. These are not mere academic debates, but flashpoints of deep-seated societal divisions. Political actors, too, exploit religious sentiments, blurring lines between faith and electoral strategy. Promises of equal treatment ring hollow for religious minorities facing marginalization. Sectarian nationalism is pushing for a majoritarian agenda. Surely this is a crisis that demands immediate examination. And surely there is no better time than now to confront fundamental questions about the viability of secularism in India. The Supreme Court plays a pivotal role in defining religious boundaries and shaping India's secular landscape. But its interventions are not seamless and sometimes inconsistent, and invite an examination into its role in upholding secular principles. In the landmark 1994 Bombay decision, a 9-judge bench of the Supreme Court, while validating the dismissal of 3 BJP-ruled state governments following the Babri Masjid demolition, enshrined secularism as part of basic structure. The judgment, unfortunately often overlooked in contemporary discourse, made crucial observations regarding the separation of religion and state. The court unequivocally stated that whatever the attitude of the state towards religion, religious sects, and denominations, religion cannot be mixed with any secular activity of the state. The court also declared that religious tolerance and equal treatment to all religious groups and protection of their life and property and of their places of worship are an essential part of secularism enshrined in our constitution. And this is not for our historical legacy and a need of our national unity and integrity, but also as a creed of universal brotherhood and humanism. Critically, the court warned, and just these words ring true today, the rise of fundamentalism and communalization of politics are anti-secularism. The court cautioned that these encourage separatist and divisive forces and become breeding grounds for national disintegration and fail the parliamentary democratic system and constitution. Importantly, although secularism was added to the preamble in 1977 via the 42nd Amendment, its principles were already embedded in the Constitution, and no article had to be amended as a result. As Bommai noted, and this is very important because what I hear sometimes, that the secularism was brought by 42nd Amendment. So Bommai noted the amendment simply made explicit what was already implicit, that is, commitment to religious plurality. Bommai and its themes are central to understanding the court's approach to religion. The Supreme Court has often had to balance competing interests like religious freedom and social reform and decide when state intervention in religious matters is justified to uphold constitutional values like equality and non-discrimination. It has addressed issues like triple talaq, the entry of women into shrines and temple takeovers, more controversial matters like Hindutva, Ayodhya, Jnanavapi has also contributed to shaping the contours of constitutional secularism, reflecting the struggle to reconcile religious diversity with a modern democratic state. The court role in this regard is vast canvas and impossible to discuss threadbare, but I will try to highlight how its ideas have evolved over time, but by tracing the court's evolving stance on religious freedom and its impact on the broader political discourse. In the 1950s, Articles 25 and 26 tasked a new judiciary in a nation defined by religious pluralism with the unique challenge balancing freedom of religion with religious denominations having the right to manage their own affairs. The landmark Shirur Mutt case, 1954, laid down the Essential Religious Practices Test, ERP test. It was created by the court to demarcate boundaries between religious autonomy and state intervention by identifying religious practice deemed essential. Ronanjay Rasain, in his seminal work, 2007 work, titled Legalizing Religion, the Indian Supreme Court and Secularism, provides an excellent analysis of the early days of ERP test. The central question in the Shirur Mutt was, where is the line to be drawn between what are matters of religion and what are not? Indeed, this has remained the central question in practically every case involving religion since. The court said that a religion is fundamentally rooted in a framework of beliefs and teachings that its adherents consider essential for spiritual fulfillment. But religion is more than mere doctrines or beliefs, and encompasses not just ethical guidelines but also rituals, observances, and modes of worship that are considered indispensable. However, the court said that the state could regulate religious practices that pose a threat to public order, health, and morality, and when they are economic, commercial, or political in their character, though they are associated with religious practice. In this manner, Shirur Mutt is remembered not just for expanding the definition of religion to include rituals and practices, but also for permitting the regulation of religious institutions. Then came another important decision in the 1958 Sri Venkatramana Devaru case, a dispute about Harijans entering a temple founded by Gauda Saraswat Brahmins, Article 26b, which gave religious denomination the right to manage their own affairs, was in play, with Solicitor General Mr. Daftari arguing that exclusion of persons from temples was not a matter of religion. The court relied on sacred text and case law, rejected this argument, and concluded, under the ceremonial law pertaining to temples, who are entitled to enter them for worship, where they are entitled to stand and worship, and how the worship is to be conducted are all matters of religion. However, the court did not apply Article 17, which abolishes untouchability. The court distinguished between excluding persons from temples open to Hindus in general and excluding them from denomination temples on grounds that the latter was protected by Article 26b. To reconcile 26b and Article 25(2)b, the court used harmonious construction to give precedence to the latter. That is Article 25(2)b, which gives the state the power to regulate all Hindu institutions, including denominational ones. So the court upheld the law permitting Harijan entry in Gauda Saraswat temples. Then a significant transformation came with 3 judgments delivered by Justice Gajendra in Dargah Committee in versus Hussain Ali, 1961, Shri Govind Lal Ji versus State of Rajasthan, 1963, and Shastri Yagna Purush Das Ji versus Muldas, 1966, the last case famously known as the Harijan entry case. These marked a notable shift in defining, in regulating religious practices. For the first time, a distinction was made between superstitious beliefs and religious practice. The court said that religious practices sprung from merely superstitious beliefs may be extraneous and unessential accretion to religion itself. The court also rejected claims deemed irrational or based on secular matters cloaked in a religious garb. It said, a claim made by a citizen that a purely secular matter amounts to a religious practice, or a denomination claiming that a purely secular matter is an affair in matters of religion may have to be rejected, as it is based on irrational consideration and cannot attract Article 25(1) and Article 26b. In the Harijan entry case, Justice Gajendra noted that although the case may have arisen because the appellant's genuine apprehension, that apprehension was founded on superstition, ignorance, and complete misunderstanding of the true teaching of Hindu religion or Swaminarayan. This was in stark contrast with court's previous stance, where it deferred to religious texts and practices protected under Article 25. Now the court asserted its authority to judge the validity of religious beliefs based on its own understanding of true teachings. Arguably, this was a move towards judicial rationalization and marked a willingness on the part of judges to challenge traditional interpretations of religious practices. The ERP test has also been used to assess temple takeovers by the state. The 1990s especially saw a spate of litigation involving major shrines like Tirupati, Vaishno Devi, and Kashi Vishwanath. The court was pretty consistent in upholding such nationalization of temples. The underlying logic was that there was higher and core religion. This is how Justice Ramaswamy approached the matter. He says that a higher or core religion is aligned with dharma, which in turn align with constitutional values of egalitarianism and national unity. It said, dharma is that which approves oneself or good consciousness or springs from due deliberation for one's own happiness and also for welfare of all beings free from fear, desire, cherishing good feelings and sense of brotherhood, unity and friendship for integration of Bharat. This is the core religion which the Constitution accords protection. The court also said religion refers to rituals, customs and dogmas based on fear and blind faith. But dharma encapsulates those great laws and disciplines that uphold, sustain, and ultimately lead humanity to the sublime heights of worldly and spiritual glory. The temple takeover project was aimed at better administration, but has it truly improved? Instead, it seems to have led to appointments of politicians and bureaucrats with consequent issues of corruption, lack of religious sensitivity, and politicization of sacred spaces, a loss of community involvement, a promotion of state-directed religious practices. So this temple takeovers is a project which needs to be revisited. From the 1960s to 1990s, Supreme Court's intervention in religious matters peaked, where it defined essential practices, judging religious rationality. The court shifted from deference to religious autonomy to active regulation, posing complex questions about balancing liberty and state intervention, judicial overreach, and imposition of secular values. Critics argued that ERP test legalizes religion, imposing subjective judicial interpretations on what is essential and non-essential, and overlooks religious dynamic nature. Selective application of the test has also raised concerns of fairness. In the next set of cases, I will discuss newer dimensions of the court's interventionist role. The ERP test, as I said, faced increasing scrutiny and challenges in recent years. Landmark cases like Sabrimala, Triple Talaq, and the Karnataka hijab case have offered alternative frameworks to this test, highlighting the tension between religious freedom and the constitution values such as gender equality and non-discrimination. The first was the decision in the Triple Talaq case, Shaira Bano versus Union of India, 2017. 3 separate judgments reflected differing opinions of the bench. Chief Justice Jagdish S. Kehar and Justice S. Abdul Nazir said, the Triple Talaq, being an uncodified personal law, fell outside the purview of judicial intervention in personal law jurisdiction, which allowed only in laws in force. So only the legislature can intervene. The courts have no power. This is following a judgment, old judgment of the Bombay High Court in Narsu Appa Mari's case. Justice Kurian Joseph declared Triple Talaq to be un-Islamic and therefore invalid. But he invalidated it being against the Quranic basic tenets rather than on constitutional grounds. Justice Nariman and Justice Lalit said instant Triple Talaq was manifestly arbitrary and violated Article 14, which guarantees equality before the law and equal protection of laws. They also said it was an irregular and heretical form of talaq, as it was believed to incur divine wrath. This judgment was a turning point. For the first time, fundamental rights were decisively used to overturn a personal law practice, setting a precedent for future challenges to discriminatory religious practices and also crucial to advancing women's rights. Soon after, in the majority Sabrimala judgment, Justice Chandrachud introduced a new viewpoint that the essentiality of religious practice often reinforces patriarchal structures, denying women rightful access to public spaces and perpetuating stereotypes that portray them as weaker and lesser being. He proposed an alternative to the ERP test. Instead of asking if a practice is essential, one should assess it if it is socially exclusionary and denies individuals access to basic goods required for living a dignified life. You will recall that the controversy was about the practice which excludes women between the age of 10 to 50. Justice Chandrachud's alternative, like the dissenting judgment of Justice B.P. Sinha in the 1962 Saiduna Saifuddin case, was that Article 25 should only protect such essential religious practices that do not impinge upon individual civil liberties. Justice Chandrachud also proffered new jurisprudence of untouchability, noting that the term in Article 17 was deliberately undefined so as to allow for expanded application. He said that the Constitution must evolve to address all forms of exclusion, and that Article 17 was applicable to the Sabrimala case, which excluded women, and mark the words, which excluded women on notions of purity and pollution. The issue, he said, was not merely women's freedom of religion, but also about their systemic operation in society. Exclusions rooted in a stigmatized understanding of menstruation effectively institutionalize untouchability. Effectively, Justice Chandrachud broadened untouchability beyond caste-based discrimination, including also gender discrimination in religious places. It is a tragic irony that such a landmark judgment, which was a significant step towards women's emancipation, was met with resistance from the Supreme Court itself, which ultimately refused to implement its own order. The absence of a conclusive resolution is a recurring and troubling pattern of the Indian judicial system. Unending reviews and references result in complete failure of timely justice. Any functional judicial system must at some point reach a definitive conclusion. In Sabrimala, a lack of stay even to this date further underscores this. The judgment of the 5-judge is not stayed, and still the Supreme Court refused to implement the judgment. So till today there is no state. The state of Kerala wanted to implement the judgment, but Supreme Court refused to intervene. Sabrimala, like its predecessor Triple Talaq judgment, highlighted the tension between religious freedom and gender equality, asking how far the court can go to intervene in religious matters to uphold constitutional values. Next came the hijab ban case, Aishpat Shifa versus Union of India, which resulted in a split verdict. The case arose from a Karnataka state government order in 2022, which banned the wearing of hijab in educational institutions where uniforms were prescribed. Muslim students challenged the order, arguing that wearing the hijab was an essential religious practice in Islam, that the ban infringed their right to practice their religion and their right to freedom of expression. They also argued that the ban was discriminatory, as a bindi or kada or some other such symbols which a Hindu student would carry, they are not prohibited. Importantly, the students never said that schools should not have uniforms, or that they should not wear uniform. They simply asked if they could wear a hijab matching the uniform color to respect their religious freedom, privacy, and dignity while still following the school's dress code. In his decision, Justice Dhulia offered an alternative to the ERP test. In the sincerely held belief, or SHB test, sincerely held belief, that is SHB, that test was used in Bijay Emunal versus State of Kerala. Now that was a case where students were expelled, certain students belonging to the Jesua sect were expelled because they refused to sing national anthem. They said that they would stand and respect the national anthem, but they would not sing because that is prohibited by their religion. So there the court ruled in their favor, saying that they are believed to be sincere and the expulsion violated their religious freedom. Justice Dhulia found these two cases analogous and thus borrowed the SHB test. He said the question should not be whether the hijab is an essential religious practice in Islam, but rather whether the petitioners genuinely believe it to be so. The SHB test is different from ERP test in many ways. While the ERP test can end up becoming theological and academic exercise for judges, which they may not be equipped for, the SHB test does not demand any deep scriptural knowledge and focuses on individuals and their rights to practice their beliefs. By focusing on subjective beliefs, it also reduces the court's role in interpreting religious texts and determining essential practices, acknowledging that religious beliefs can be personal and varied even within the same religion. In some ways, it also emphasizes freedom of conscience guaranteed by Article 25(1). We are all forgetting that the basic tenet of the article is freedom of conscience, requiring that the state should not dictate what constitutes an essential practice. Justice Dhulia's opinion on the SHB test is a studied examination of the impact of hijab ban on privacy, dignity, and freedom of expression. He has made a conscious attempt to shift away from the previous rigid doctrinal interpretation of religion to a more individual-centric and flexible understanding of religious freedom. These cases have demanded a consideration of alternative framework that move beyond the limitations of ERP test. One alternative is to focus on constitutional morality, which emphasizes constitutional values like equality, non-discrimination, and dignity, and prioritizes the Constitution's transformative potential in addressing discriminatory practices. Another alternative is non-discriminatory approach, which focuses on whether a religious practice violates fundamental rights, particularly the right to equality. This approach emphasizes the need to safeguard women's rights within religious communities and entails an assessment of whether a religious practice violates fundamental rights without having to ascertain whether it is essential or not. These alternative tests, while offering potential solutions to the ERP test limitations, also raise their own challenges and reflect the complex and evolving nature of religious freedom jurisprudence in India. The challenge lies in developing a framework that respects religious autonomy while also ensuring that religious practices do not violate fundamental rights and social justice. No discussion on secularism and the Supreme Court is complete without reference to Justice J.S. Verma's judgment in the Hindutva cases, a series of 7 decisions. These judgments centers on the allegations of electoral malpractice involving members of, among others, BJP and Shiv Sena, who were accused of violating the Representation of the People Act 1951, which prohibits appeal to voters based on religion or the promotion of religious enmity. In his judgment, Justice Verma controversially equated Hindutva with Hinduism and with Indianness. He said that Hindutva was a cultural civilization concept, a way of life, not a political or religious agenda. He relied on an inclusivist understanding of Hinduism that emphasized tolerance and universality, which had also influenced the court's definition of Hinduism in Yagna Purush Dasji, where it was called an amorphous way of life. It's very difficult to define Hinduism. So in Yagna Purushji, the Justice Gajanarkar, who was a great scholar on Hinduism and great Sanskrit scholar, so he described it as way of life. He borrowed heavily from Dr. Radhakrishnan and the Vivekananda and many other philosophers. This interpretation, Justice J.S. Verma's interpretation, problematically ignored the exclusive strand of Hindutva as articulated by Savarkar and Golwalkar. I might add that as a young adult, I have read practically all of Savarkar's works in the original. My grandfather, paternal grandfather, was the president of All India Hindu Mahasabha. So Savarkar's concept of Hindutva was fundamentally territorial. Please understand what Savarkar said in his essay on Hindutva. Savarkar's concept of Hindutva was fundamentally territorial, defining a Hindu as one whose land of their ancestry, that is Pitru Bhumi, and of their religion, that is Punya Bhumi, lay within the geographical boundaries of India. In contrast, Muslims and Christians are foreigners, for they are not indigenous, and their religion originated in separate land. Savarkar himself said, Hindutva is not identical with what is vaguely indicated by the term Hinduism. By an ism, it is generally meant a theory or a code more or less based on spiritual or religious dogma or system. So the whole essay of Savarkar is to make a distinction between Hindutva and Hinduism. Ignoring Savarkar's own distinction, Justice Verma conflated the terms. In his judgment, he also relied on two Supreme Court cases. One was in Swaminarayan case, that Yagna Purush Dasji, which I referred to, and the other from 1976, CWT versus R. Sridharan. Both cases emphasize the broad, encompassing nature of Hinduism, but neither use the word Hindutva and only mentioned Hinduism. Justice Verma, however, concluded thus, and I'll tell you the effect of this conclusion. No precise meaning can be ascribed to the terms Hindu, Hindutva, and Hinduism, and no meaning in the abstract can confine it to the narrow limits of religion alone, excluding the content of Indian culture and heritage. It is also indicated that the term Hindutva is related more to the way of life of the people in subcontinent. These were the words used by Justice Gajanarkar about Hinduism and not Hindutva. His judgment failed to recognize Hindutva as a political ideology, a fact acknowledged even by its proponent, Savarkar. This distinction is vital, as equating Hindutva with Hinduism blurs the lines between religious identity and political agenda. The way of life metaphor helped legitimize the Hindu nationalist narrative, with Hindutva equaling Indianness. The judgment allowed Hindu groups to claim that their ideology was merely of Indian culture and not any distinct political agenda. Now, see the effect. This marginalized minority identities and perspectives as the Indian way of life becomes synonymous with Hindu cultural norms. So you will find a new uniform civil code is practically the replication of the Hindu law. It's not in what way it is unifying, that's not the subject of the lecture, but I really fail to understand that a uniform civil code, Ambedkar said, that a reform code should not be introduced. He said, I'm using his own words, that only a mad person would impose it on the populace. He said that it has to be introduced with a concurrence, with a consultation with all people. That was his thought at that time. So, ultimately, Justice Verma's decision demonstrates the challenges interpreting complex socio-political terms within a legal framework. While his intention might have been to prevent the misuse of religious rhetoric, in effect, it created more ambiguity and potentially legitimized communal appeals. Many of you may recall that Hindutva judgments were referred to a larger bench. But after having sat on the reference for 18 years, Supreme Court took it finally and said, on this judgment, no comment. This is, if I may so, with disappointment, a particular trend of the Supreme Court, and is a fate that has befallen so many other judgments in the past and may impact more in the future. This brings me to the decision in Ayodhya dispute. A significant marker of all conflicts involving religious identity in India. When the 5-judge bench delivered its decision, it felt like the definitive end of a 135-year-old legal saga. The subsequent construction of the Ram Mandir with its Pran Pratishtha, a grand spectacle attended even by some of the judges who authored the verdict, appear to signal closure. But the Ayodhya chapter is far from closed. It demands critical examination, especially at a legal gathering like this, where dispassionate analysis can shed light on its complexities. Despite the temple's construction, the issues that fueled the dispute continue to simmer, reminding us that we still may have not achieved complete societal reconciliation. The initial point of contention in Ayodhya was a chabutra, a platform, outside the Babri Masjid. The dispute simmered for over a century, culminating in the mosque demolition in 1992, which shook the nation and triggered widespread communal violence. Soon after, a presidential reference was made to the Supreme Court asking whether a Hindu temple pre-existed the mosque. The court then declined to answer the question. In his commentary at that time, Nani Palkhe was a great visionary and far-sighted person. So he wrote in 1993 in Times of India, courts can deal with questions of law or of fact. They are not qualified to deal with questions in other fields like archaeology or history. However, the court was ultimately drawn into this dispute to answer questions of faith and belief. In its judgment, the court acknowledged the existence of a mosque. So that was constructed in 1558. That is the finding. Secondly, the court said the Babri Masjid was a Sunni and not a Shia Waqf property, and the mosque was not constructed after demolishing the Ram temple. So the whole political narrative that a masjid came by demolishing Ram Mandir was rejected by the Supreme Court. It firmly accepted that overnight in December 1949, Hindu idols were installed in the mosque and that the 1992 demolition was unlawful. In fact, the court accepted that injury had been caused to the Muslim plaintiffs, that is the injury in the form of violation of legal rights. The court then awarded 2.77, that's the area where the Babri Masjid stood earlier, for constructing a Ram Mandir to the Hindu parties, and an alternative space of 5 acres for a new mosque to the Muslim plaintiffs, citing its extraordinary powers under Article 142 to do complete justice. Just before he took oath, I think Mr. Venugopal spoke on this Article 142 extensively. He said that it's all subjective satisfaction of the judge. Whenever they want to do something, they would invoke Article 142. Scholars like, do you think that the justice has been truly done in this case? Professor Faizan Mustafa, a great legal scholar, have said this, that this judgment will be remembered as a victory of faith over the rule of law, as the court conceded to religious beliefs even in deciding a property dispute. And despite conceding that faith cannot confer title, that's a finding, a faith cannot confer title to a property, it still went ahead to give property to worshippers on the basis of faith. Scholars also point out that to the decision's uneven appreciation of evidence, Muslim plaintiffs were held to be an exceptionally high standard. The court questioned the consistent use of the mass for namaz before 1856. So the court wanted proof that namaz was offered in the mosque from 1558 to 1886. This is in spite of the fact that admittedly namaz was offered in the mosque till 1949. In contrast, the criticism is Hindu parties were not subjected to the same scrutiny of historical verification of their claims. Another matter is that of addenda. An anonymously authored document of over 100 pages, which was not a dissent, but titled addenda, appended after the main judgment and attributed to one of 5 judges. We don't know who that judge is. While purportedly in agreement with the main judgment, using Sanskrit verses and references to ancient Hindu texts, the addenda delves into whether the disputed structure is Lord Rama's birthplace according to Hindu faith. It states, it is thus concluded, and on the conclusion that faith and belief of Hindus since prior to construction of mosque and subsequent thereto has always been that Janmasthanam of Lord Ram is the place where Babri Masjid has been constructed, which faith and belief is proved by documentary and oral evidence discussed above. This was not the position of the majority judgment. They did not accept this stance at all. Now, such an addenda, according to me, in my respectful opinion, is highly unusual and impermissible. Mr. Upendra Bakshi used the word impermissible. And unknown to judgment writing in India, I never heard of a judge adding an addenda without even disclosing who is writing that particular document. Madhav Godbole, the Home Secretary when the demolition took place, hoped that Ayodhya judgment would bring closure to the dispute and prevent future cases such as around Mathura or Varanasi. However, his optimism was misplaced, as the judgment has done little to quell underlying socio-political tensions. We can see this in the host of other cases that have arisen in the wake, notably Gyanvapi. In its Ayodhya verdict, let's see now what the Ayodhya holds on the secularism being basic structure and what it says about 1991 Places of Religious Worship Act. The court recognized the 1991 Places of Religious Worship Act as part of Constitution basic structure. The law prohibits the conversion of any place of worship, save Ayodhya, because Ayodhya was already in court, and mandates that the character of a place of public worship shall not be altered, and seeks to impose a positive obligation to maintain the religious character of every place of worship as it existed on 15th August 1947. The court also relied on parliamentary debate to establish clear legislative intent to bind those who govern the affairs of the nation at every level. So this law should be followed by governors, those governing the nation at every place, every stage. And that these norms implement the fundamental duties under Article 51A and are hence positive mandates for every citizen as well. Accordingly, the court, while declaring again that secularism is a part of the basic structure of the Constitution, said that any future amendment or repeal of the law is rendered unconstitutional because these principles are non-derogable and based on the principle of non-retrogression. It means that this law cannot be touched at all. So this is the law that there has to be a status quo as on 15th August 1947. We cannot go on raking up disputes, I mean, on basis of some historical grievances. Immediately after the Ayodhya decision, a host of other cases came to the courts. The Gyanatvapi case was one such, where 5 Hindu women sought permission to worship deities allegedly inside Varanasi mosque, which they claimed was built on a demolished part of the Kashi Vishwanath temple. A Varanasi civil court ordered a videography survey of the mosque in 2022 to ascertain the deity's existence. The survey, facing protests and legal challenges, led to the discovery of an alleged Shivalingam, prompting the court to seal the area and restrict namaz. Notably, the Supreme Court refused to stay the survey and made a distinction between defining the religious character of a place of worship and conversion of a place of worship. This is completely contrary to the court's stance in the Ayodhya verdict on the matter of basic structure. The court has repeatedly refused to stay the matter. This bench was presided over by Justice Chandrachud, as he then was. Later, of course, Justice Chandrachud has stated that these were mere oral observations. Nevertheless, these observations virtually opened a Pandora's box, leading to several such claims and even leading to communal violence in places like Sambal. Now, a bench led by Chief Justice Sanjeev Khanna has stayed all proceedings and directed the court to refrain from entertaining such matters. The case holds profound implication for the very idea of secularism, making its resolution fundamentally important. Ladies and gentlemen, cases like these are not just legal battles. They define the very soul of our nation. Delays on issues like constitutional validity of Places of Worship Act, of the Citizenship Amendment Act, and the unresolved constitutional validity of Love Jihad laws, all left lingering for years, erode public trust and create climate of fear. When state leaders openly threaten death for interfaith marriage, in our family, we have 3 interfaith marriages. So the Chief Minister of Uttarakhand said that there might be a penalty of death in case of an interfaith marriage, which violates that law. So in this situation, the Supreme Court's role as the guardian of our fundamental rights become absolutely crucial. Protecting secularism, the bedrock of our Constitution, is the greatest challenge and its greatest responsibility of the Supreme Court. But laws alone cannot create a truly secular society. We need to complement laws with its dissemination of reason, the promotion of critical thinking, and an unwavering embrace of inclusion. We must challenge forces of religious orthodoxy and communalism that infiltrate institutions or permeate into society. True nationalism is not about erasing history or rewriting narratives to fit particular agenda. True nationalism is about embracing our diverse heritage, fostering empathy, and respecting the right to dissent. It is also about constitutional patriotism, a deep-seated fidelity to constitutional principles, not blind loyalty to the state or its current leaders. We cannot allow ourselves to be consumed by endless debates over historical grievances and religious disputes when far more pressing issues like poverty, unemployment, and social inequality demand urgent attention. We owe it to the future generation to build a nation where the principles of secularism, democracy, and freedom are not merely abstract concepts or words on paper, but lived and breathed realities for every citizen, regardless of their background or belief. Let's focus our collective energies on building a nation where inclusion, justice, and opportunity is extended to all. Thank you.
Thank you so much, sir, for the enthralling and engaging speech, a true indication of the depth of knowledge and an analytical mind. Now I invite Mr. A.R.L. Sundaresan, the present Additional Solicitor General of India, to render the vote of thanks.
Honorable Mr. Justice A.P. Shah, former Chief Justice of our High Court, the Honorable Judges of the Madras High Court present and past, Honorable Justice Sharma, who has come here, my esteemed senior friends, juniors, students, good evening to all. I am really happy that I have been given the opportunity of proposing the vote of thanks. Seeing Honorable Justice A.P. Shah here again, it brings back the memories of us appearing as juniors before him in the first court. It was really pleasant. Those days we will have the folded bundles. On the back side of the bundle, 3 or 4 points would be there, whether to admit or not to admit. As soon as the case is called, Honorable Chief will see that side and then look at us. Then we know whether we are going to get it yes or no. It just brought back that memory. And for today's lecture, 75 years of Constitution, I just was imagining, suppose there is another function after 100 years and somebody is given the same topic. He need not go back to 1950 up to 2025. He did not read that. If he has this lecture in his hand and then sees the march of law from 2025 to 2050, he would do a good lecture. That was the way in which Honorable Judge has analyzed the Constitution and all the judgments from that date till date. And we are really proud and happy that Your Lordship has come here for giving us the second lecture of the series which is organized by the Senior Advocates Forum. I thank the convener, the secretary, co-conveners for arranging the series of these lectures. I thank all the honorable judges, all my friends for taking time to join us in this evening. Thank you very much.
Can I request everybody to stand up for the national anthem, please?
पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत